Good morning, Ms. McConnell. Pleasure to meet you.
Oh, Mr. Craner, I can't say it's a pleasure to meet you. I've been inundated with all of your complaints, and I don't know if I appreciate it.
Well, how about we try to put an end to that and determine a sufficient settlement in order to avoid trial?
I wouldn't mind a settlement, seeing as trial is in 1 month and I'm not prepared since I don't know how to try a case.
Interesting. Well, before we begin, I have a form that I would like you to sign.
What is this?
Well, this form is stating that anything said during this negotiation is without prejudice to my client's rights. Essentially, we do not omit any fault during these negotiations, even though we may speak of fault in hypothetical terms.
Okay, I'll sign this. But remember, if you discuss something that is otherwise discoverable, this little agreement of yours does not exclude such discoverable material from evidence.
Yes, I understand that. I believe that's Rule 408. I know your background, and obviously you know your federal rules. That's great.
Okay, so my truck driver is guilty because he says he had a red light.
Oh, really?
Oh, no, wait. Let me rephrase.
Okay.
Now, let's assume for the sake of these negotiations only that my truck driver was negligent. What damages are you looking for?
Well, as he is negligent, we're looking for a total of $10 million.
What if the truck driver had a green light?
Well, hypothetically speaking, if your truck driver did have a green light, then there would not be any negligence on his part.
Oh, so you admit that my truck driver had a green light?
No. Remember, first of all, I spoke in hypothetical terms, and remember that little agreement that you signed?
Yes.
Anything I state automatically includes the disclaimer in that agreement.
Sure it does.
Well, I've had enough of these negotiations for today. I'll see you at trial. All this hypothetical stuff is annoying me.
Brandon, how is your case going with Carnival?
Well, we're in the opening stages. I guess you could say stage 1. I just filed a suit and I'm conducting some further research on the matter. Oddly, this is not a popular occurrence.
Have you contacted the lawyer handling the case?
Yes, I've exchanged some letters with the lawyer and provided him with some preliminary documents. Like I said, this is not a popular occurrence, so it's hard to figure out what the law is, and I'm trying to determine what type of lawyer he is.
Why is that?
Well, depending on his style of lawyering, I will know how to negotiate with him and how the negotiation will go, or at least have some information about a possible negotiating style.
What do you think the relationship between the two of you will be like?
Well, even though I filed the complaint, I think he believes he's in charge since he works for this big company, Carnival. I'll let him think that he has a position of dominance. Right now, I'm going to find out some more background information about the lawyer, like school, work history, etc.
Good. Good luck with all that. Make sure you show him your position, though.
Oh, I did. In my letters, I informed him of my position and that I am inalterably committed to my position. I took a bit of a maximalist approach.
What do you mean by maximalist approach?
Just that I am asking for more, probably way more than I expect to get.
I hope the number was too high and it loses its effectiveness because it's unreasonable.
Oh no, it wasn't too high, and I think it is effective.
Good. I'll let you get back to work. Brandon, how is the case of the Carnival?
Everything is fine right now. We just started some serious settlement discussions. I guess you could say that we're in stage 2.
How are the discussions going?
Well, we're talking about the legal and factual issues, which is difficult since there isn't much to compare to this situation. I was able to get some minor concessions, I believe.
Oh, that's good. What type of approach are you using?
Well, I'm trying the problem-solving approach.
What is that?
I'm trying to determine what the other side's positions are to learn information about their interests and their needs. I'm using a lot of why questions.
That sounds good. Keep up the good work.
Stephanie, I'm almost in trial with Carnival case and I haven't reached an agreement.
Hey, that's all right. Calm down.
I'll try. Stage 3 is rather stressful though.
So what are the negotiations like right now?
Well, there have been many concessions and on each side, and I think we're coming so close to an agreement. I think we're closing in on a wall though, because neither side will budge much further. I might try bridging this gap somehow.
Well, maybe you should give them your final offer.
I think I will. They can take it or leave it or come up with something else that I like, but I'm going to have to give a final offer.
Good luck with that. Hey, Brandon, shouldn't you be in trial right now?
Actually, yes, I should be, but thankfully we came to an agreement during stage 4.
Oh, really? How did that happen?
Well, Carnival accepted my final offer, and my client is pretty happy with the agreement, so am I.
That's good to hear.
Yes, and thank you for your help.
Have a good day, you too.
All right.